I'm so thrilled that there are so many people here who want to talk about the Clean Power Plan. My husband would be absolutely shocked that this many people want to hear me talk about this. But I wanted to give kind of a brief overview about what the Clean Power Plan does, how it works, the litigation that's underway right now, both at the federal and at the state level. There's kind of some interesting wrinkles with how that's been played out. How hard it will be for Colorado to comply, what the lift kind of looks like, and then also what we as people in Colorado can do to support the Clean Power Plan. So what is the Clean Power Plan? The Clean Power Plan is a federal regulation that places limits on the amount of carbon dioxide pollution that can be emitted from fossil fuel-fired power plants. And a lot of people are kind of shocked to hear that this is the first federal rule of its kind, that we don't already do this, that we don't already regulate greenhouse gas pollutions from power plants. But it establishes carbon emission limits for each existing power plant within the United States. And it allows states a whole ton of flexibility, which we're going to talk about, to determine how they're going to specifically meet those standards that have been set for them by the Environmental Protection Agency. And why it matters. This is, like I said, the first time that we've undertaken a regulation of greenhouse gases from existing power plants. And the power sector represents a huge source of greenhouse gas emissions. This is why WRA, since the 80s, has been focused on trying to reduce the environmental impacts of the power sector, because if you can change energy, you can change so many other things about our economy. It's the biggest opportunity that we have right now, frankly, to reduce greenhouse gas emissions and to do something to address climate change. It's also the foundation of the United States' commitments in the Paris climate talks. So this was really the cornerstone to everything that we committed to do in Paris. So if this falls apart for whatever reason, I think there are real consequences in terms of that international agreement and other countries that are looking to us to be a leader. So this is kind of a wonky chart, but I think it's really powerful. The green line that you'll see there is essentially what we need to do in terms of emissions from the power sector in order to stay on track for only 2 degrees of warming, which most experts agree is the standard. That's kind of the max that we should reach. You can see that business as usual, if we don't do anything besides what we've already decided to do, we're going to get to those purple lines, and the red diamonds are where we'll be if we fully enact the Clean Power Plan. So the Clean Power Plan is a critical step to getting us to that 2 degrees standard. It's not enough though, and we all need to be clear that if we're going to do what needs to be done to address climate change, the Clean Power Plan is just one step in the right direction. So how did this start? Where did the Clean Power Plan come from? Well, you probably remember that back in the 2000s, there were multiple attempts to try to pass some federal legislation dealing with climate change. It seemed for a while like we might actually do something, and then we didn't. And in 2007, the Supreme Court ruled that carbon dioxide is a pollutant and that it must be regulated under the Clean Air Act. This case actually happened when I was in law school in Washington, D.C., and I showed up at the court at like 5 o'clock in the morning or something to try and watch the arguments because I wasn't thinking ahead that most of the people that were there had really good camping equipment because they were all hippies and they had been there since like 3 the last afternoon. So I didn't get in. Anyway, in June 2013, President Obama issued his Climate Action Plan and essentially kind of nudged EPA to get going on regulating greenhouse gas emissions from the power sector. And then in August of 2015, the final rule was published. So that's the rule that we're dealing with now. So let me talk a little bit about how the Clean Power Plan works and what it does. And we're going to get into the Clean Air Act, which is, I think, one of the most complicated statutes that we have in terms of environmental law, so I'm going to keep it super high level. Essentially, the Clean Air Act authorizes EPA to set limits on harmful air pollutants to protect both public health and the environment. These include ambient air quality standards. So if you read in the newspaper about how the Front Range isn't in compliance with ozone, that's an ambient air quality standard that EPA has issued under the Clean Air Act. It also creates source-based emission limits, and that's what we're talking about for the Clean Power Plan, because it's specifically targeting existing fossil fuel-fired power plants. It's only a specific kind of source of pollutant that this regulation applies to. So states develop plans to comply with those standards that EPA has developed, and then they wrap them up in a nice little bow and hand them over to EPA. And EPA puts on its glasses and evaluates whether or not the plan is good enough. If it is, they stamp it with a big smiley face and give it back to the state, and then the state enforces it and enacts it. If it isn't, then I guess they stamp it with a frowny face, and they have the authority to come in and enact their own plan. So they'll say, Colorado, you can't be trusted to do this, obviously. We're just going to take over. There are also some other consequences for states not complying with these federal air regulations, like loss of federal highway funding and other things of that nature. So Section 111D of the Clean Air Act allows EPA to establish emission standards for existing stationary sources that emit other kinds of air pollution. So it basically says, if you're already kind of in our bucket of regulation, then we can use 111D to regulate other pollutants that there's not a specific standard for. Established emission standards have to reflect what's called in the statute the best system of emissions reduction. And we're going to talk a little bit about what that means, and specifically what it means in terms of power plants. The BSER, the best system of emission reductions, has to be something that's been adequately demonstrated, so possible, and something that's cost effective. So when EPA is setting these standards, they're taking into account, is it possible technically but not economically, then it's not going to pass as BSER. So typically, when you're talking about most pollutants, BSER would be a widget. It would be a thing that you can tell that I'm not an engineer, it would be a thing that you put on your plant that makes less pollution come out, right? For example, you would have a flue gas scrubber, like there's a fancy picture here of a flue gas scrubber. That's what we would typically think of as the best system of emission reductions, and that's the way that 111D works for some other pollutants. But for the power sector, there's kind of a challenge here, which is that there's no adequately demonstrated technology right now that you can just stick on your plant and reduce carbon dioxide from your power plant. There's no widget right now that's cost effective. So the solution that EPA came up with was to recognize that fossil fuel-fired power plants are part of this broader system that we think about as our electricity system, our electric grid. And within that system, there are a lot of other things that you can do in order to reduce the overall carbon emissions from the system. And when you look at the ways that states have already taken steps to reduce the carbon pollution from their power sector, it's been through things like renewable energy standards, energy efficiency standards, fuel switching requirements, those types of things. So EPA looked at these types of broad, more holistic policies that states have undertaken when it was thinking about what's the best system of emission reductions. So the way that EPA set the standards for each source is that it looked at these three building blocks. So it basically said, we think there are three things you can do as a general matter to reduce carbon pollution from your power plants. One is that you can just run them better. You can improve your heat rate, make them more efficient, so you're getting more out of them but running them in a better way. The second thing they said you could do would be to switch some of your electricity generation from coal to natural gas plants that you already have. So don't run that plant over there, run this plant because we think it's a little bit cleaner instead. So you're kind of switching your load and rebalancing how the system is working. And the third thing was adding renewable energy to the system. So these are the three kind of building blocks that EPA relied upon when they set the standard for each state. And it's a lot more complicated than that. There are regions and balancing areas and heat rate improvement scores and things like that. You don't need to know about any of that. All you need to know is that essentially what EPA did was they said, here's what you have. If you applied these three standards, what would your baseline be if you did these three things? Now, it's important to realize, however, let me go back a little bit, that although EPA used those 3 building blocks to set the emission rate standards under the Clean Power Plan, states don't have to do those things. So they're kind of using those as tools when they're doing the math to figure out what your standard should be. But if you want to meet your standard by retiring a bunch of coal plants or by doing some genius new thing that nobody's ever thought of, you can do that. You don't have to use the building blocks that EPA used to set the standards. That's just how they determined what was technologically feasible. So when you look at what the standards are, again, there are standards for both coal and natural gas plants. You can see how the standards progress there in that chart. And each state has both an interim and a final standard. So the interim standard is in 2020, and then there's a final standard in 2030 that states are going to have to reach. And when you look at Colorado's standard, you'll see that this is the mix of generation that we have right now, this right here, this thing. So that's what we had before. That's what they used when they set the standard. They assumed that we had 75% of our generating units were coal and 25% of them were natural gas. And that's how they came up with the standard for Colorado. Now, one important thing to note about the way that the Clean Power Plan works, like I said before, it gives states a lot of flexibility about how they're going to meet the standard. And in some ways, that's one of the things that makes it the hardest to explain the Clean Power Plan, because you can really come into compliance with it like any way you want. The world is your oyster. You're young and beautiful. You can do whatever you want. There's so many options for states that it can be kind of difficult to wrap your head around. One of the big options is that you can comply either through a mass-based standard or a rate-based standard. And I'm just really briefly going to explain the difference between those two things. A mass-based standard is what we're kind of more, as somebody who used to work in air pollution regulation, that's what we're kind of more comfortable with. It basically says you can emit 10 tons of carbon per year. Don't emit 11, don't emit 12, 10. That's it. You're cut off, right? That's a mass-based standard. A rate-based standard, on the other hand, is more concerned with how many tons of carbon you're emitting per megawatt hour of electricity you're producing. So how dirty are you each time you're creating a megawatt hour of electricity, as opposed to just having a cut limit and you can't go above that? And that matters in terms of the kinds of steps that states are going to take to come into compliance with the Clean Power Plan. It also matters because it changes how difficult or challenging it might be to administer the plan, just as a state government, as a regulator, how much work you're kind of taking on. So this mass versus rate standard, it's just an important thing to keep in mind as one of those big choices states are going to have to make when they're thinking about how they're going to come into compliance. So when you look at the rate-based standard, this kind of shows you who's going to have a more difficult time meeting their standard as opposed to some other state. And there's been a lot of, when the Clean Power Plan initially came out, there was a lot of moaning and groaning, I think, among the states about like, oh God, why do they've got it so much easier? Like Vermont doesn't even have any power plants, so they don't even have to do anything. That's not fair, Vermont. So there's different standards depending on where you are, and I think that is one of the reasons why you see different states have such different opinions about the Clean Power Plan, is because for some states, like Nevada, it's kind of like, yeah, we're done, it's no big deal. For some states like Wyoming, it's going to be a much harder lift for them. So that's something to keep in mind as well. Colorado, we'll get into how Colorado is positioned under these different lenses that you can look at for the Clean Power Plan. So again, that's the rate-based standard. And here's the mass-based standard. So this is, you can see that some states are actually allowed to increase their mass-based emissions under the standard, and that's just because it's a weird rule. But we can talk about that later if you want. But again, even under the mass-based standard, states have different compliance lifts. When you look at states in the West, you can see that a number of us are pretty well positioned to be able to come into compliance with the rule. You can see Nevada, like I was talking about, they're almost there. Arizona, also very close. Colorado, we're actually a lot closer than we look through this chart. when you compare us to Montana or Wyoming, those states that are going to have kind of a harder time reaching those standards. So this is just a reminder again that those building blocks that EPA used to set the standards, that's all they were used for. And as soon as the standards are set, you can toss them out the window and do whatever your heart desires as a state. You don't have to do those things that the building blocks said that the building blocks said when they were setting the emission standards themselves. So I'm sure that a lot of people here have probably heard about the Clean Power Plan, the litigation. It's been really harrowing, like really way more exciting than I ever thought that it would. This is like the nerdiest thing to say. It's probably not harrowing to anybody else. I find it to be very interesting what all has happened so far. So I wanted to give you guys just kind of a taste of what's going on from the legal realm. So there are tons and tons and tons of lawsuits. There are 27 states right now that are suing the Environmental Protection Agency, combined with a bunch of industry groups and other fossil fuel interests. Those cases have all, at this point, been consolidated in the DC Circuit, and they're currently pending there. There are also a number of states and local governments and environmental organizations who have intervened in those lawsuits in order to help defend EPA. They're helping to defend the rule. And just to note here, Colorado is in this really interesting place in terms of the Clean Power Plan litigation. As you probably know, our governor and our attorney general are independently elected executive figures, and our governor is a Democrat and who likes the Clean Power Plan, and our Attorney General is a Republican who does not like the Clean Power Plan. The Attorney General on her own, without the authorization from the governor, decided to join the lawsuits suing EPA over the Clean Power Plan. The governor said repeatedly that he did not want the Attorney General to do this, that, hey, I'm the client here. What are you doing going around suing the federal government? I don't want you to sue the federal government. He actually brought a lawsuit in the state Supreme Court and said, whoa, 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 can she do this? Shouldn't I have some say here? I'm the supreme executive. You know, she's independently elected, but I'm the governor, for God's sakes. Court, this is a really big deal. Stop what you're doing. Decide this right now. They filed a Rule 21 petition, which is essentially a way to try to get the court's attention right away. The Supreme Court said, doesn't seem like that big of a deal. Go try a lower court first, and then if you still want to talk about it, we're here. So they denied that Rule 21 petition, which leaves this big question open about, well, gosh, can the Attorney General sue the federal government if the governor doesn't want her to? Who is her client? Is it the people of Colorado? Is it the governor? How do you deal with conflicts of interest within the Attorney General's office? Because the attorneys who are advising the Air Pollution Control Division, the Public Utilities Commission, the Energy Office, all of the executive agencies that are busy working to implement the Clean Power Plan, they all answer to her. So what does that do? It raises all of these questions, and unfortunately there's no answer right now. So it's just kind of this really big legal mystery that I really hope at some point will be resolved, because I think it's very interesting. So that's the status of our own unique Colorado drama, but then there's been also a ton of drama in the federal courts. So originally the plaintiffs filed a motion with the DC Circuit Court and asked for a stay. And a stay is basically pushing pause, hold up, don't do anything. This is such a crazy rule. If we have to implement this, it's going to be all sorts of trouble. Just put a plug in this until we figure out if it's actually legal or not. They filed this request for a stay with the DC Circuit. The DC Circuit denied it, which everybody expected them to do. The plaintiffs then requested a stay from the Supreme Court of the United States. And the stay was issued in February while I was on vacation, and I was getting all sorts of all caps text messages from people like, oh my God, what happened? And this stay is in effect until either the Supreme Court denies certiorari and basically says we don't want to hear it, which is super unlikely since they already issued this stay, or until they make a decision and they say like up or down, this is good or bad. So that means kind of everything stops for a while, at least in terms of the federal implementation of the Clean Power Plan. And we'll talk a little bit about what that means for states. Some of it's kind of unclear, some of it is more clear. But one of the things that's notable is that the issuance of this stay is really, truly unprecedented. The Supreme Court has never before interfered to pause an administrative rule pending judicial review. Nobody's even heard the merits of this case yet, and they put a stop to it. This has never happened before. It has ramifications for all sorts of administrative law, and every presentation I give has to have a picture of Lawyer Dog in it. He was shocked, just absolutely shocked. So again, that was a really big deal. That happened on February 10th. And then 2 days later, Justice Scalia died. And that was crazy. So that radically changes the dynamics about what we expect to happen with the Clean Power Plan. The reason why is because most people are saying, and I'm no expert on the internal machinations of the federal courts in DC, but smart people that are have been predicting that the DC Circuit Court, because of the panel of judges that was assigned to it, was likely to be decided in EPA's favor, that it was a panel that was going to lean favorably to the government. Like I said, because they granted the stay, it's almost certain that the Supreme Court would then grant certiorari, which means they would want to hear an appeal. If there's a 4-4 split, which now that Scalia is no longer with us is almost guaranteed, that would mean that the lower court's ruling would be upheld. That's what happens when we have a 4-4 split, a tie on the Supreme Court, which is, I would just put as an asterisk here, one of the reasons why courts are really, really, really important and why it is absolutely critical that we have 9 justices on our Supreme Court. So Scalia, I mean, it's just been a roller coaster in terms of when the stay was issued, everybody that I know was just like, oh. And then when we heard about Scalia, it was like, oh God, maybe the Clean Power Plan is alive, like it might still work. So it's just been a roller coaster. So I want to talk a little bit about what the compliance obligation is going to look like for Colorado. And this is going to involve a lot of charts. So I apologize in advance unless you like charts, and then you're welcome. So Colorado, I'm sure those of you that are in this room know how great and wonderful we are. We've really been a leader in clean energy here in Colorado. We were the first state to adopt a renewable energy standard by popular vote in 2004. We were the first state to enact legislation surrounding community solar gardens. We had the Clean Air, Clean Jobs Act, which I was intimately involved with, which was a plan in 2010, which switched a lot of our coal-fired generation over to cleaner resources. And we've had a really strong energy efficiency standard for almost a decade. Now, these policies have left us in a really good position to comply with the Clean Power Plan. We're in a much better position than we would be had we just sat on our hands. And so now I want to talk a little bit about the analysis that WRA has done when we say we're well positioned or our compliance lift isn't as big as some people might think. I want to explain a little bit about what that means and how we get there. So like I mentioned at the beginning, the majority of my work, of the work within our clean energy program, is practicing in front of public utilities commissions in utility regulatory proceedings. So every utility, whether they're fully regulated investor-owned utilities or municipally owned utilities, they go through a resource planning process. And in that process, they basically say, heck, we're a big giant utility. We can't just make decisions overnight. We got to think ahead here. So let's look at the next 10 to 15 years and really think about what's Colorado going to look like? How many more people are going to move here? How much electricity are they going to make? Is everybody going to get an iPad? Are they going to want to charge it all at the same time? Are people getting rooftop solar? How many new resources do we need? And they'll make plans. They'll commit to taking certain actions. I'm going to buy 200 megawatts of wind in 2022, or I'm going to retire this coal plant in 2028, or whatever. They've got these long-term resource plans of things that utilities have already committed to do. Now, a lot of the analysis that you'll see about the Clean Power Plan is done from the top down. It's kind of people working in DC or people with a federal perspective taking some national assumptions and then applying them to each of the individual states. We at WRA, since we are in the weeds, wonky nerds, we did the opposite. We started from the ground up and took out all of the utilities resource plans and said, okay, well, it looks like they're going to retire this in that year, so let's plug it into the spreadsheet, and then they're going to do this, and they're going to refire that. And so we built up a reflection of what utilities in Colorado are already planning to do. If nobody did anything more than they were already committed to do in their existing approved resource plans, this is pretty much where we would be, that top pie chart there, right? And I've got a bunch more graphs, so don't worry. The bottom is kind of where we would need to be roughly if we were going to come into compliance with the plan. And again, those illustrative compliance scenarios, it's important, again, to keep in mind, like I said, there are a jillion ways you can come into compliance with this rule. So it's not as though you've got to do X, Y, Z. The state has, again, so much flexibility to figure out the best way for Colorado to comply. But these are some ways that we've been thinking about. So let's look at where Colorado is from a rate-based perspective. So here you'll see the blue line there, that's EPA's standard for Colorado. So you can see that interim target in 2020, we've got kind of a significant drop there. And then we go down a little bit more, we've got that 2030, the final target of where we've got to reach. That orange line there is where we already are. It's what we've already committed to do. So you can see that just by moseying along, doing what we were already going to do, we're about 70% of the way there. It's not really going to be that big of a lift, and we're almost in compliance with the interim standard. Now, this is, again, looking at the state as a whole. If you look at why we're so close, like I said before, it's those great policies that Colorado has already implemented. It's our super successful renewable energy standard, it's the Clean Air, Clean Jobs Act, it's the energy efficiency, almost over 520 gigawatt hours a year of energy efficiency. These are the reasons why we're so well positioned today. And I think we as Coloradans and our legislators, as much as I might not want to say this sometimes, kind of deserve credit for all of the great things that we've done. We were really forward thinking in a lot of ways when it comes to this clean energy future. Now I want to talk you, remember I said there are these two ways that you can comply. You can comply rate, which is what we just looked at, or you can comply mass. If we look at the lift from a mass-based perspective, it looks a lot different, right? It doesn't look nearly as good. The reason why, you'll see that we're still good for that interim target. And the reason why our emissions go up like that in the out years, again, is because we're using these currently approved publicly available resource plans, and they include certain assumptions in those out years that are unlikely to be realistic, but are what are contained in utilities plans right now. So for instance, one of our large utilities currently in their plan anticipates that they're going to run one of their large coal-fired generating units a lot more in 2022 or so. I don't know that that's particularly likely, but that's what's in the plan right now, and we're giving you the information that's in the plan because that's what we do. So I wanted to talk a little bit about the timeline. What does this mean? What is Colorado doing? What is the pathway that we're going to enter down to come into compliance with this rule? And you can see that, so right now we're kind of in this stage. States holding stakeholder processes to shape the compliance plans. Basically, a lot of very smart people sitting in rooms together, looking at spreadsheets and graphs and models, and figuring out what's the best way for Colorado to comply with this rule. The deadline under the rule for states to submit an initial compliance filing is September of this year. But the bar is super low. Basically, a state just had to file something that said, we're working on it, and then they got an extension. You could get an extension for another 2 years. So there are some incentives in the plan to try to get you to act early. There's some extra credit you can get if you get your plan in and submitted and approved earlier. But essentially, the compliance deadlines don't begin until 2022. That's the first time that you're actually held accountable for being in compliance with the rule or not. But there's this stay. So it's kind of unclear what happens right now. To remind you, again, the stay is in effect until the Supreme Court acts on the federal litigation. It only controls EPA's implementation and enforcement of the Clean Power Plan. It does not say, states, thou shalt stop doing anything related to reducing carbon from the power sector. It just says, EPA, you can't basically whack anybody on the knuckles for not being in compliance because we haven't decided whether this rule is actually justified yet or not. A lot of people who are trying to capitalize off of the stay have said that, well, the fact that the stay was issued means that all of these deadlines are going to be pushed out, and there's no point in doing anything because everything's just going to be delayed indefinitely. And we frankly just don't know if that's true right now. Remember back when Lawyer Dog was so shocked because this has never happened before? We don't really know what happens to the compliance deadlines in light of the stay. It's likely that some of the interim deadlines, like that September 2016 deadline for the FONSI application, will be extended, but it's not clear that the 2022 or the 2020 or 2022 compliance deadlines are actually going to push out as well. We just don't really know right now. So that's something to keep in mind. And let's talk a little bit about what we all can do to support the Clean Power Plan. The main thing is, it's important to realize Colorado is still moving forward with thinking through these issues. It's still performing analysis, it's still looking at different modeling tools, it's still thinking about, gosh, what is the most cost-effective way that we can reduce carbon emissions from the power sector. It's still doing that technical work right now. And I think there's a really important role for all of us to thank both the administration and the Colorado Department of Public Health and Environment, who are truly dedicated and unthanked public servants for the work that they're doing to continue this really important work. And it's also important to notice that Colorado's not some rogue state out there still continuing to plan. We have a lot of company, a lot of really good company. There are a lot of other states who realize, well, stay or no stay, gosh, it's probably in our best interest to still be figuring out what's probably going to happen sometime. If we delay, it's only more likely that from a legal or a regulatory perspective, we're going to find ourselves behind the 8 ball. And if you remember back to the very beginning of this presentation, there are big consequences for being behind the 8 ball. If the stay is lifted, the Clean Power Plan is upheld, and the compliance deadlines aren't significantly extended, that means the federal government can come in and force a plan on Colorado. They can tell us how we're going to comply, as opposed to us having the ability to decide for ourselves how we want to comply. So it's really important to be thinking about being proactive right now in order to set Colorado up in the best possible space moving forward. Another thing that you can do if you are a glutton for punishment is participate in the stakeholder process. And this is just kind of a really brief overview about all of the different decisions that these regulators are going to have to make about how they can comply with the Clean Power Plan. If you feel super strongly that, damn it should be a mass-based standard with new and existing sources, then you should go and tell CDPHE that and participate in this stakeholder process. They're taking input from everybody right now about how we should come into compliance with this rule, what makes sense, what kind of things should we be considering, what are the long-term impacts that we should be weighing. So if you have that kind of technical expertise, there's absolutely a place for you to be involved in the stakeholder process. Another thing that you can do is help us prevent state legislative attempts to derail the Clean Power Plan. We saw bills last year in the state legislature that were intended to obstruct the Clean Power Plan, essentially, and we've seen even more of them this year. These are 4661 and 1157 are three that I'm aware of right now that I've testified against. They came out of the Senate and they're now headed towards the House. Each of them, in various different ways, would make it less likely that we would be able to comply with the Clean Power Plan. Either they're putting up bureaucratic roadblocks to our ability to submit a plan on time, or they're stripping authority from the air pollution regulators that they already possess to regulate carbon. just as an aside here, the state always has the authority, even if there was no clean power plan, the state could regulate carbon on its own. It could decide that regulating carbon from existing power plants was really important to protect the health and well-being of Colorado citizens, and it could take that action. We don't need the Clean Power Plan as a state to move forward to act on climate. Some of these bills would strip that authority from the state and remove our ability to ever regulate carbon at just the state level, which I think is pretty problematic. There's also, and I just became aware of this in the last couple of days, but there have also been some incredibly extreme attempts to defund the Air Pollution Control Division as part of the state budget process. One of the proposals that I became aware of would defund 92 state employees who administer the air quality control program. This would include the entire oil and gas enforcement unit, all people who write permits, all people who do any kind of stationary sources enforcement. It would essentially remove, our enforcement ability from an air pollution perspective would be just a sad old pug with no teeth. It would be like the least threatening thing you could possibly think of. It would have absolutely no ability to hold polluters accountable and to protect our air quality. It would also be incredibly detrimental for businesses who rely on the issuance of permits in order to conduct their affairs, which are completely within the realm of the law. So some of these attempts are just so short-sighted and so reactionary to the Clean Power Plan that they have the impact, or they have the potential to really disrupt air quality from a much broader perspective, where we could see an increase in air pollution across the board, not just carbon. So in summary, the Clean Power Plan is a super critical, very important step in acting on climate change, but it's not all that we need to do. We need to do the Clean Power Plan, and we need to do more. Colorado is really well positioned, and it's continuing to work on development of a plan regardless of the stay, and for that, the state should really be commended. And finally, the Clean Power Plan is not the last or the only step in reducing emissions. And with that, I'm happy to take any questions that you might have.
Well, thank you very much. I would also recommend, if people are into this subject, to go to her Twitter feed, which has interesting updates on issues relating to that. So we have a microphone here, which I'll walk around. This is Easy Stefano. And why don't you say your name?
Sure. Yeah. Thank you for the presentation. It was great. My name is Stefano Chiovetto, originally from Italy. But I've been living in Colorado for 18 years. I've been in the energy industry for about as much, especially hydroelectric. Anyway, I saw a lot of talk about carbon dioxide, and I wanted to ask, what about methane?
So that's a great question. Methane is really important from the perspective of actually curbing climate change. Methane is not addressed by the Clean Power Plan. Methane is not what we think of as a stack emission from power plants. It's really involved more in the production of the fuels, so either from coal beds or in oil and gas production. And so there are separate attempts by both the state and federal government to regulate methane in those kind of upstream production contexts, but it's not at all impacted by the Clean Power Plan.
Yep, Paul Bellinger. A question regarding mass versus rate. Isn't mass more important in terms of total emissions or total carbon into the atmosphere, or how are they different in that regard?
They're calculated by EPA in order to be roughly equivalent. So the idea is that you would have to take the same types of compliance measures in order to come into compliance with either the mass or the rate-based standard. I think there are a lot of benefits to the mass-based standard. From what you're saying, I think that it's easier to quantify, well, how much carbon are we actually producing without having to figure out what your kilowatt-hour denominator is. I also think that if you have a mass-based standard, it's a lot easier to scale it up to deal with other industries. Ultimately, a carbon regulatory structure that only focuses on the power sector, it's a good first start. I'm not talking down on the Clean Power Plan. But like I said, that's not going to get us where we need to go. So in order to get to that next step, I think to the extent we can use the Clean Power Plan to create a framework that we can then use to control carbon across our economy, I think that's going to be a lot more valuable. And that's where a mass-based standard has some real advantages.
Hi, Jim Sipser. I work for E9 and Insight. Is it fair to assume that the deadlines will also be subject to lawsuits if the stay stays in place?
Well, if the stay stays, then any deadline that's occurring while the stay is still active is automatically vacated. So for that 2016 deadline, it's impossible that the stay is going to be lifted before it comes, and so that is automatically gone. What's that?
They wouldn't be made retroactive.
No. And so I think for those ones where the time passes while the stay is still in effect, you're going to have questions about, well, where does that pick up? But for the ones that are in the out years, because one of the things about the Clean Power Plan is that it gave you a lot of time to figure out your plan. You could get this 2-year extension because, I think the administration recognized that this was really complicated. The power system is really complicated. So I think it's a real question mark right now. What's going to happen to those deadlines that were in 2018? Do they get pushed back or do they stay there? We don't really know right now. But I don't think that would be part of separate litigation. I think that would probably be resolved as part of this case.
Erin, very nice talk. Thank you. In the Energy Act, there were 3 approaches given, but energy efficiency was not one of them. But later you brought energy efficiency in a lot. Could you explain why the change?
Yes, absolutely. So energy efficiency is kind of interesting. It was in the proposed version of the rule that came out last year, that came out in 2014, a year and a half ago, energy efficiency was a building block. So there were 4 building blocks. There were 4 things that the EPA said that they thought you would be able to do. In the final rule, energy efficiency was taken away, and they no longer used energy efficiency or an assumed energy efficiency potential as something that they took into account when setting the standard. Now, that's not to say that you can't use energy efficiency to come into compliance. You absolutely can. And in fact, energy efficiency is one of the most cost-effective ways that we can reduce emissions from the power sector. So it's still absolutely a tool in states' toolboxes if they want to use it to come into compliance with the rule. There are some administrative and regulatory complexities with utilizing energy efficiency, particularly with a rate-based standard. It requires a lot of measurement and verification that you don't have to deal with from a mass-based standard. But it's still absolutely a tool. I think there were probably some slightly tricky legal issues surrounding requiring someone to consume less of your product as a means to reduce your pollution that the EPA decided to just kind of back away.
The reason I asked that was that I gave testimony when EPA held its hearings here twice. Both times I introduced the subject of carbon dioxide removal, carbon negativity, and I've tried to follow it in regulations that EPA has, but I'm totally unsure what the present situation is.
Yeah, and I think something like that, even though it's, again, one of those tools that could be really valuable in terms of the overall acting on climate, just like controlling methane emissions from fuel source production, you wouldn't be able to use it for compliance with the Clean Power Plan, but we should still be looking into it and doing it. It's just not going to be a tool for Clean Power Plan compliance.
That doesn't make sense to me, given that states can propose something else.
Yeah, I think they can propose something else. It's just got to be something that's related to the power sector. So if it's got to be in that system, right, of the best system of emission reductions. So some people will try to get really big and say, well, electric cars, let's count them towards Clean Power Plan compliance. And that's not really, it doesn't have anything to do with actual electricity generation. It's reducing greenhouse gas emissions, but from the transportation sector, it's actually probably increasing emissions from the power sector in certain places. So it's one of those things where I think it's an important component. And if you can tie it into electricity production, if you had an actual carbon neutral electricity producing machine, again, not an engineer, then I would think maybe you could use that for like a negative ERC, or like you would get a positive a credit for it. I'm mixing up my terms here, you know what I'm saying? But if you're thinking about it in some other context that's not related to electricity production, you can't really use it for Clean Power Plan compliance.
The word compliance has come up so much that I would actually like to refocus and ask, hey, what are we getting if we comply? Because I think it's called the Clean Power Plan, but it's really about dirty power and the stuff that dirty power does. And I would like you to talk a little bit about what also gets removed other than CO2, because there are other pollutants that play a big role, have huge health impacts, and that we're really well off with a plan that reduces pollution.
Yes, that's absolutely true. The Clean Power Plan is focused on carbon emissions, but there are so many coincident pollutants that are associated with power plants, so that if you're reducing pollution from the power sector generally, you're going to have a whole host of co-benefits. So one that's really important for us in the Front Range is NOx. So if you reduce pollution of nitrous oxides, that's a precursor to ozone, and that's going to help us come into compliance with our ozone standard. It interacts with volatile organic compounds in the atmosphere and turns into the ozone that makes it hard for my son to breathe on bad days. So that's a really important benefit. You've also got mercury emissions from power plants and a whole variety of other things. You've also got waste streams like coal ash and things like that. So when we're talking about the Clean Power Plan, it's important to recognize that we're acting on climate, but we're getting a whole bunch of other benefits as well. And just to highlight one other thing, that I think so many times I find that opponents to the Clean Power Plan or any kind of clean energy try to frame this issue as, well, we can either act to reduce greenhouse gas pollution and pay a whole bunch, or we can do nothing and pay nothing. And isn't paying nothing better? Everybody likes paying nothing. But that's not the choice. There are true, honest to God, concrete costs with doing nothing. There are threats to our national security, to our infrastructure, to our health, to our beautiful Colorado way of life and our tourism economy that are going to be impacted if we refuse to act on climate. And one of the most interesting things is that you'll hear people talk about, well, you're just raising energy rates and you're going to hit the poorest among us the hardest by increasing energy rates. There's actually a really interesting study that was put together by the EPA that looked at the costs associated with failing to act on climate, with failing to do anything. What are the costs? And they looked specifically at electricity rates. And they found that if you do nothing and climate change continues unabated, your electricity rates are going to go up probably more than they would if we did something about climate change. And the reason why is because severe weather events that are disrupting our transmission and distribution grid, increased temperatures means that everybody out there is going to want an air conditioner and they're going to be running it all at the same time, which means we're going to have to build even more power plants. So the choice isn't pay something or pay nothing. The choice is pay something and don't live in a post-apocalyptic hellscape, or pay something and do. I mean, to me, that seems like a pretty easy choice as somebody who's watched Mad Max, but that's just me.
Well, that was a great answer.
Don Phillipson. I'm a lawyer, so I have to ask a legal question. What are the primary arguments used by the people who are opposing the Clean Power Plan in order to try to overturn it?
There are a number of arguments. I'll just give you kind of the top three that I know of. One is that best system of emission reductions only means a widget that you can put on your plant. And looking outside the fence line of a particular plant is not appropriate. There are a variety of reasons why I think that argument will fail, in part because we've used outside the fence line strategies to comply with emission standards before. Acid rain and the trading program that was created around that is a great example. Another argument that you'll hear is that the version of 111D that passed out of the House in the 70s is different slightly than the version that passed out of the Senate in the 70s, and EPA picked the one they liked better, but there are these two versions, and they had no authority to pick which one they liked better. I think that's kind of a ridiculous argument. EPA has a ton of deference. They get to interpret their statutes unless they're being completely ridiculous about it. And then the third argument has to do with, well, there are a couple of other ones, but the one that I'll raise here that we've heard a lot in Colorado, that we've heard Cynthia Kaufman saying, is this idea that the Clean Power Plan is encroaching on state authority, that states have traditionally regulated electric utilities and the electricity system, the power grid, and so EPA, by coming in here and telling us that we have to do renewables or we have to do whatever, you're encroaching on this sacred thing that we've always done as states. And again, there are so many environmental regulations that control the power sector right now. The Clean Power Plan, even though it's big and hairy and complicated and has building blocks and acronyms, it's still just an air regulation. And we can implement it and enact it in the same way that we do any other air regulation under this great system of cooperative federalism that we have.
I'm Alan Best, and my question has to do with the nexus of power within state government. Now we have the PUC making decisions, we have the state agencies, but my question has to get to, we don't have one power provider in Colorado. We have the investor-owned utilities, we have the co-ops, we have the munis. They don't necessarily march together. In the context of Colorado, but you could say the same thing in Utah or Wyoming, how will this power play out? Who will make the decision? Because there will be perhaps some unpleasantness along the way.
No, it's going to be great.
Yes. But you see what I'm getting at. How do we?
Of course.
Yes.
Right. So, I think this goes back to what I was saying before, that at the fundamental basis, this is an air regulation like any other air regulation. And so that's the place to start, right? It's true that the PUC, where I call home, they don't exercise regulatory authority over tri-state, for instance, or over the municipal utilities, but the air regulator, they have jurisdiction over everyone. So when I think, if I were queen and I could say how this was going to work, which I'm not, so don't put money on it, but I think there's a really clear pathway here, which is that the air regulator creates a compliance framework. Ideally, I think we would like to see probably a mass-based standard with new and existing sources with a trading component so that you can utilize the most cost-effective reductions along the system. The air regulator sets up that framework, right? That's what air regulators do. They're great at that. They write it into your permit. You can emit 10, you can emit 11, you can emit 12, right? Done. Then, for the regulated utilities, like Public Service or Excel, they would come to the Public Utilities Commission and they would say, all right, well, we can only emit 11, so here's how we're going to deal with it. We're going to bring on a bunch of wind and we're going to do a bunch of energy efficiency and it's going to work out great. And the PUC says, I don't know. Okay, fine, approved, right? And then the other utilities would go through their own processes. They do these kind of long-term planning exercises already. They might not be public like the PUC process is, but Tri-State has a process that it undertakes in order to come into compliance with these types of environmental regulations. Municipal utilities go through the city council process. So I can see each utility going through to their regulator or their overseer or their board and basically saying, all right, well, we've got this standard and now here's how we're going to meet it. I think that there has been some disconnect, I think, between the different state agencies, but we in Colorado are really fortunate in a way because of that Clean Air, Clean Jobs Act that I mentioned before. So that piece of legislation basically said, it didn't have anything to do with carbon, but it basically said, there's a whole bunch of federal environmental regulations coming down the pipeline that are going to affect the power sector. Regional haze, ozone standards, all sorts of things. Oh my gosh, this looks really scary. Utilities, could you just get together and kind of deal with this in our own way and like think across pollutants and think long term? And that statute created a structure for the PUC, the Public Utilities Commission, and the Air Pollution Control Division, which is within the Colorado Department of Public Health and Environment, to work together, to come together and kind of figure out this plan that was then going to get submitted to EPA. So even though the threads of communication are not ideal. I'm not sure everybody's like going out for brunch on Sunday or whatever, but it's way better than I think it probably is in a lot of states. And I know that those agencies have been talking, which is good.
The same thing could apply also to Wyoming?
Well, Wyoming doesn't have the benefit of our wonderful Clean Air, Clean Jobs Act. So I'm not sure I don't know as much about the kind of internal politics of Wyoming. But that same process in terms of the air regulator comes up with a framework, the regulated utilities go to their economic regulators, and the municipals go to their city councils. That could work in any state. You know, that's kind of a framework that could be applied in any state. And that's one of the valuable things about an approach like that, not to get too nerdy here, is that it really helps to differentiate the authority between the two agencies. It really keeps the air regulators looking at air regulation and the economic regulators looking at economic regulation. And it also doesn't create the risk that some element of a plan, like I'm going to add a gigawatt of renewable energy, if you put that into a plan that you submit to EPA and EPA approves it, that's now federally enforceable, which means that any Joe off the street, if you don't get your 1 gigawatt of renewables, can come in and sue. Who would they sue? You? The state of Colorado? It's not really quite clear. It creates a lot of sort of uncertainties when you talk about putting nuts and bolts energy policy into a state plan, which is why I think it's easier to just kind of like walk away from all of that and just create a strict air program and then deal with the implementation over here with these people that know that world.
Again, thank you so much for your presentation. Martin, I hope you can get that up on YouTube and we can all Twitter it out to get a real positive twist on this stuff. So thank you. And this might be something Stefan should have asked. And it's okay if you don't know the answer, but I noticed hydropower going down in both of your graphs from 3% to 2%, both for the plans of the utilities and for what Western suggested. So that seemed kind of interesting to me for the state that has spearheaded at least small hydro across the country. Do you have any idea why that hydro is going from 3 to 2%? And it's okay if you don't. I don't expect you to know all those.
I don't know, but
Okay.
I know someone smart who does know. So if you wanted to follow up with me afterwards, I could put you in touch with her.
Robert Youngberg, I've spent a lot of time with the Nebraska utilities in my career, but one of the odd technologies or different technologies, innovation technologies maybe, is there's a big carbon black plant that produces hydrogen, and they're going to be building a plant to use that to generate electricity at Hallam, Nebraska. But that'll amount to about 25% of their need to meet their clean power plan. So it's a very unique technology. Mm-hmm. And my other question is, if I recall correctly, the Clean Power Plan allows various states and regions to go together to create a plan. Has anybody done that?
That's a really good point, and something that I should have mentioned. That's absolutely true, that states can trade with each other. There's kind of a little bit of lack of clarity right now about whether you have to be only mass states can trade with mass states and only rate states can trade with rate states, or whether mass and rate can play together. It's kind of looking like the answer is no, but it might be yes. It might be that, technically it's feasible for mass and rate to trade with each other. But this is one of the kind of weird prisoner's dilemma-y things, I think, about the Clean Power Plan planning that's going on right now, is that I think a lot of states are going to be looking around at their neighbors and saying, well, what are you doing mass? Because if you're doing mass, then are you doing rate? Well, maybe I want to do rate. So everybody's kind of looking to see what everybody else is going to do, because that's going to impact how their ability to trade with other people and perhaps monetize the gains that they have, or sell the credit. If they've done a really great job, like Colorado, maybe there's a financial opportunity there if they're able to trade with other states. So I think that trading thing is going to ultimately be really, really important. But no state has come out and said, I'm for trading and I'm for mass and I'm putting my stake in the ground. The conversations aren't quite there yet, but I think a lot of states are going to find the trading option pretty attractive.
And I want to add that the person who asked there is Bill Ritter, and the people who work at his New Energy Economy Institute at CSU in Fort Collins. So.
Yes, he has been bringing together representatives of a lot of the Western states to have these conversations so that hopefully we're all kind of moving in the same.
And he sounded actually quite upbeat the last time I heard him, because there's a lot of interest in these Western states to address the issue proactively. And trading schemes actually tend to fly.
My name is Norbert Klebel, and I would like to bring a dimension to your topic, which I think is hard to grasp for the legal community, but on the economics and technical side, I think these charts going out to 2030 will be influenced by something which has already changed our situation in the last year, namely an aggressive move away from coal. Because coal production, even in the United States, is much more expensive than other fossil fuels. And the fact that 80% of all coal companies have now declared bankruptcy, or at least Chapter 11, is not a one-time shot. They are not coming back. So other fossil fuels, particularly gas, but also renewable energy, will have a much bigger impact than all the plans the power companies have made. And so the legal fight might dampen down because the economics take over.
And I think that that's absolutely true, and we have already seen that, as you alluded to, we've already seen that happen today. I think from our perspective of looking at these utility resource plans, we're just looking at what's in the ground kind of right now. A lot of big utilities, at least the two big regulated utilities in Colorado, Public Service, Xcel, which is what normal people call them, and Black Hills, are going to be starting their resource plans, updating their resource plans this year. And so I think it's going to be, we've already heard some very aggressive renewables numbers coming from Xcel. So I think there's going to be some big changes in what those resource plans look like, even just in the next couple of years.
My name's Eric Linke. I'm an engineer, so I'm a little out of a fish out of water. But I just had a question. So you were talking about, I think one of your earlier slides had ambient air as kind of one of the things that the government kind of looks at. I was just kind of curious ambient air kind of drifts around from state to state, and how do they decide if you're in compliance with ambient air, or if that's a valid question?
Yes, we in Colorado are very sensitive about that, because Utah, our neighbor, is not a very good neighbor, and they're always giving us their ozone. At least that's what the air people say. The way that there's different standards for each of the ambient, there's only like 7 or 8 ambient air quality standards that EPA controls, and those all are tested through monitoring systems spread out throughout the state, and then they take essentially a rolling average where you exclude like the 4 worst days or the 3 worst days over 2 years or 1 year. It's kind of a complicated math that's individual to each one of those different pollutants, but the way that you test it is through this monitoring, and also through a lot of very technical modeling of what we expect the air would be doing and how it would be moving. But it's really an interesting subject, because at least on ozone, I've heard complaints that the ozone standard is getting, I think 70 parts per billion is what we just lowered it to. And that's getting pretty close to just the natural background levels of ozone that we see in Colorado in some parts of our state. So it also has to do with the geography of your particular state and the topography of your state, how it works. And I think there are some legitimate questions about, does a national standard make sense for certain types of pollutants in certain types of states? But that's, a fancy modeling question that's far beyond my lawyer brain.
But it's an interesting question because it also, in one fell swoop, invalidates the Cynthia Kaufman argument that the EPA shouldn't meddle, because that's obviously nonsense. If pollutants, be it ozone or be it CO2 or whatever, does not stay within state boundaries, you'll have to manage it federally. So,
which was the argument that was presented in Massachusetts versus EPA, which was, hey, this is coming from all over the place, and we're tiny little Massachusetts. We're going to get swallowed up by the ocean if you don't do something. That was exactly their argument.
Well, let's give a hand again to our presenter, Erin Overturf. And thank you so much for coming.